Hey folks, welcome. We are just letting the video populate and then we will go live. And we're live. Welcome everybody to Trump Trials and Tribulations, October 26th, 2023. I am here in the virtual jungle studio from the Nondescript Hotel studio in Philadelphia with Roger Parloff in his portrait gallery, Quinta Jurecic, not in the Ansel Adams studio. What studio are you in, Quinta?
I'm in the Socialist Realism studio today.
In the Socialist Realism studio, and Anna Bauer in, I believe that, if I'm not mistaken, is the Three Pleas in a Pod cafe room, reading room.
That's right.
All right. Well, welcome to you all. It's been a busy week of news. So since we did a whole podcast about the three pleas, we're not going to spend a lot of time on the pleas that have happened, but we would be remiss if we didn't gossip about the juicy subject of pleas that have not yet happened. So Anna, bring us up to date. Who has pled out of Fulton County and who are the best rumors about?
Right. So we've had Jenna Ellis, Ken Chesbro, and Sidney Powell, and Scott Hall. Everyone always forgets that Scott Hall was first, who have all pleaded out in Fulton County. So we started with 19 defendants, and now we are down to 15. That took me a little bit too long to do. But we're down to 15 defendants, and we expect that, that number will get even smaller as we continue through this case. There's some new reporting from CNN that there are at least 6 other plea deals that have been floated and that are maybe still in the works, or that there are talks about. And interestingly, within that reporting, there are a number of folks who are mentioned that have not been offered deals. So that's Eastman, that's Trump, that's Mark Meadows, and then that's Giuliani. And of course, those are the people who are the kind of top billed defendants. In case folks don't know, in RICO indictments in Georgia, it's kind of like a movie where you have your kind of cast in order of their, kind of starring role. And on the Fulton County indictment, I believe that the order is Trump, Giuliani, Eastman, and then Meadows. So very much the strategy that Ben and I discussed, which was Fani Willis is very likely willing to offer a lot of deals to some of those lower level defendants, and then would be probably very happy to just whittle the number of defendants down to maybe those 4, maybe even less than that. So I think that, in terms of people I'm watching right now, I'm watching Mike Roman. His team, I think, has kind of signaled that they might be interested in a deal. And it sounds like from the recent reporting that those talks are continuing. And then I'm also watching Misty Hampton. It is my understanding that, it seems like maybe she would be willing to make a deal. I'm not entirely sure why one has not come together yet. But I'm watching that to see what happens. And then, of course, there's a few other people that I think would be candidates for a deal, but I'm not entirely sure what's going on with those folks. So everybody just stay tuned, and we'll see who is next in the pleas in Fulton County.
Yeah, so I want to go into some of that speculation, but before we do, I want to bring up a question from former Estonian President Toomas Ilves, who emailed this question in, and I know it's one that's on everybody's mind, which is sparked by Sidney Powell's announcing that the 2020 election was in fact rigged and that the plea was extorted from her. And Tomas asks, what happens when someone pleads guilty and then goes back on their plea agreement? Which, of course, is something that Sidney Powell knows a bit about, having represented Mike Flynn in doing exactly that. So, first of all, for those who don't know the law on this, what is the law if you go into court and you go under oath and swear that what you're about to say is the truth, and you plead guilty and you allocate to the facts, and then you go out and give a press conference and say, actually, it was extorted from me. I didn't do any of it. It wasn't voluntary. And by the way, the election was rigged. What is the legal status of that? And secondly, what happens just as a normative matter if you do it?
Who are you addressing that to?
Just to
I
the
was
peanut
addressing
gallery.
it to Anna, but anybody who wants to take it should.
Well,
Oh,
yeah, Anna.
I feel like, no, Roger, I feel like you will be able to answer that in terms of the federal system. And then maybe I mean, I'm not entirely sure that I have a different answer, but you go ahead and then we'll go from there.
Well, in terms of the federal system, you really nailed the person down pretty well during the plea hearing, and they allocute and they sign a statement about what they're pleading to. I found it much mushier, just watching what was happening in Georgia, and so it's I mean, what does happen is the case is restored and you go to trial on the original charges. But in Georgia, I don't know what they'll do. A judge would immediately demand that the person come back into court to discuss what just happened.
Although,
Yeah,
I mean, sometimes they
don't
don't.
know. I mean, I would need, go ahead.
I mean, it's a fairly common thing for people to plead out to things and then say socially, yeah, I just did that because, they had me over a barrel and it wasn't true. Generally speaking, if you do not come into court and say, I want to withdraw my plea, your plea stands. And
That has not
there
been
are
the case.
situations.
That has not been the case in the January 6th cases. A lot of these guys have strolled out of court and said that, no, I didn't mean that. And, Judge Lambert says, oh, really? Come on back in then, because we can.
That's interesting.
We're ready to go.
Because that's what happened in Flynn's case too initially, and then he did ask to withdraw the plea. But there are lots of cases, and one of them is Michael Cohen, by the way, who just testified in the Trump civil case that he was lying during his plea and didn't, and this was under oath, and I doubt very much that they're going to haul him into court for and so some of it has something to do with how long you take to do it, right? And also, how emphatically you do it, I think. But I would actually be surprised if she is hauled back into court to answer for this.
That seems very strange, especially because it's this first offender status, and you're getting all this. Lenient treatment, and the idea is you stay out of trouble for X amount of time and it goes away, and then she gets out of court just hours later and says, oh, it was all a lie. I mean, how can you go forward with it? It's crazy.
Well, I have not. Oh, sorry, Quinta, you go ahead.
I was just going to say, I think it might be helpful to give more background on Flynn and Sidney Powell here before we jump to the Georgia case, if that's okay, Anna. So for listeners who may not remember, the reason why I think we're maybe so spun up about this, at least in part, separate from the fact that it's just an odd situation for someone to plead to something and then immediately walk out the door. And undercut what they just said. So Michael Flynn, of course, Trump's former national security advisor, pleaded guilty as part of the Mueller investigation. I believe 2 or 3 years later, then ditched his counsel, hired Sidney Powell as his counsel, and as Ben said, went ahead and filed a formal motion to withdraw his guilty plea. Which the judge was not pleased by, I think we can say, and it led to some extremely contentious back and forth. And the case...
Well, you're actually skipping a step. So he pled, and then he and Sidney Powell both made some statements out of court while his cooperation was still going on that cast doubt on it. And the judge hauled him back in, much the way Roger describes, although this was when the case was still pending. So to answer for it, at which point he moved to withdraw it.
Right. And the whole thing eventually went away only because the Justice Department under Bill Barr decided to actually drop the case. All of which is to say that Sidney Powell is no stranger to this kind of thing. And I do think it's worth noting that at least before she pleaded guilty, she was trumpeting her representation of Flynn in those proceedings in some of her filings challenging the ethics charges against her in Texas. So this is something that she is quite proud of, or was until at least recently.
And Anna, have we heard anything about this being brought to the attention of Judge McAfee? Does the DA seem concerned about this? Or is this, something that the press is interested in, but the case is very much moving on?
No, I haven't heard anything about that. I mean, maybe it has been brought to their attention. It's unclear to me. I will say, this has not been an area that I have looked into, or a piece of news that I've looked into a whole lot, but I would need to look at what exactly she said or what exactly she posted, because I'm not even really sure that there, if you look at the conditions of her plea, I'm not entirely sure. She does have this condition where she's not supposed to talk to media about the case, but I don't know that there is necessary. And Jenna Ellis, they added a condition which was like, you can't post on social media about the case. But I would need to look at exactly what Sidney Powell said to really understand whether it is something that might violate one of the conditions of her plea, or kind of suggest some kind of broader willingness to withdraw her plea agreement, because I'm just not sure. But I will say that I don't know that, because Sidney Powell pleaded to these very specific set of facts about, what she did with respect to Sullivan Strickler and in Coffee County. I don't know that her saying the 2020 election was stolen, while very Sidney Powell and wrong. I don't know that that's inconsistent with the set of facts that she pleaded to in Fulton County, if that makes sense. So,
I think that. Sorry, go ahead, Roger.
In a federal case, the thing that it's the extortion thing. This was extorted. I mean, if
exactly.
you take that, a plea has to be knowing and voluntary, and if you're saying it was extorted, I can't imagine a federal judge that wouldn't say, oh, well, then let's come on back and retract it and let's go forward. Trial on Monday.
Right. I think it's, I think the claim that the plea is extorted is probably a bigger problem than the claim that the underlying statements about the election. All right, so one more thing on Fulton County before we move on. What do we know about now that the decks have been cleared, assuming that they don't drag Sidney Powell back for trial on Monday? what do we know about when we're going to have a trial date?
Well, we don't know much. We do know that Judge McAfee has a scheduling order that is that relates to the larger group of co-defendants that includes Trump and Eastman and all the 15 others who have not pleaded out. And that means that dispositive pretrial motions are due the first week of January. I believe it's January 8th, I want to say, that those motions are supposed to be in. So it's possible that McAfee could just wait until all those motions come in and then, set a trial date after that. He could go ahead and set a trial date now, but, he's got a few things he needs to keep in mind in setting this date. One is that a number of these co-defendants who are in the larger group still have removal proceedings going on in terms of their appellate litigation. So you've got Mark Meadows, David Schaefer, Sean Still, Kathy Latham, and Jeffrey Clark, who have all been denied removal to federal court, and they're now appealing to the 11th Circuit. And the 11th Circuit has said that they're going to hold oral argument on December 15th, which means that that's the earliest date, of course, that an 11th Circuit opinion might be handed down. Unlikely they're going to hand it down the same day as oral argument, so it's probably going to be a little bit later. And then we have an inevitable appeal likely to the Supreme Court. So Judge McAfee is going to have to decide, is he going to sever those removal defendants or just wait until that litigation has been exhausted? Because he's raised this question before of whether, if on appeal, any of these defendants get removed, would that mean that the whole case gets removed? And if you went ahead and started a trial, it might implicate some of the double jeopardy issues that arise under Georgia law, because jeopardy attaches when the jury is sworn. So he's got to think about that. He also has to think about the March 4th trial date in the January 6th case before Judge Chutkan. Judge Chutkan has been very set on starting in March. And I think that Judge McAfee, this very young state court judge, is going to be a little bit hesitant to, set a sprawling RICO case for January that is expected to last 5 months, when that might, carry on over into the March date and affect the date for the January 6th federal case in DC. So he's got a lot to think about there, and I'm really not sure what he's going to do. I know Trump also has arguments that he might make about why it should be set later, because he's got some civil cases in January and February as well. So super unclear at this point what will happen in terms of a trial date. Your guess is as good as mine.
And what about that removal litigation? We still have Mark Meadows, who has I think we all agree, the best case for removal is in front of the 11th Circuit. There are some other defendants who also have 11th Circuit appeals. And there's been no proof of life from any 11th Circuit judge, right?
Well, we won't find out who the panel is until, I think it's you typically in the 11th Circuit, you can call like 2 weeks before the oral argument date. And then that's when you find out who is on the panel. And before that, it's not publicly available. The only sign of life we've seen from that panel of judges who is deciding the merits of Meadows' case is they ordered additional briefing from the Fulton County District Attorney's Office and from Meadows' team on this very specific question. It takes a little bit of explaining, but basically, there's a question within the statute of whether removal applies to just current federal officers or also to former federal officers as it relates to, acts that they did in the scope of their office. Meadows, of course, is a former federal officer. So if the statute does not apply to former federal officers, then that kind of defeats his bid for removal outright. And the 11th Circuit, in a different case called Pate, that was just handed down a few weeks ago, had looked at a very similar kind of statute and asked the same question of whether that statute, which I will say is a criminal statute that criminalizes retaliatory liens against federal officers. And they asked kind of a very similar question of, does this statute apply to former federal officers or just to current federal office holders? And the answer that was a very kind of textualist answer that they gave was that no, it doesn't apply to former federal officers. And they kind of went through this very textualist analysis in which they decided, that former federal officers were excluded. And so the 11th Circuit in Meadows' case has said, how does Pate, that decision, apply to the decision that we're making here? So, I think that the Fulton County District Attorney's Office is going to take this opportunity to, again, reiterate their argument that former federal officers like Meadows are not allowed to remove under the statute because the statute doesn't apply to them. And then Meadows is probably going to try to distinguish Pate on various grounds. So, for example, the fact that that was a criminal statute, whereas this has different kind of policy considerations because it's a removal statute. So, there's various arguments they both can make, but that's kind of all that we've seen from the 11th Circuit so far.
Yeah, my guess is that Scott McAfee will not set a trial date while there is removal litigation pending, because you've got all this other stuff to do and there are other trials in the way. And so there's no reason to set a trial date now. And if you do, then you could run into that double jeopardy problem or just have to push it off. All right, so we are going to keep an eye on Fulton County for purposes of additional pleas but basically, and for motions, but basically we are going into a little bit of a Fulton County suspended animation. Is that fair?
I think that's fair, yeah.
All right. However, Judge Eileen Cannon has been super busy. She finally held that Garcia hearing. Roger, what do we know about the Garcia hearing? What happened?
Well, she approved Woodward, Stanley Woodward. If you remember, the issue had been Woodward represents Walt Nauta, one of the co-defendants, and he also represents or did represent a guy named Trump Employee 4, who has been reported to be—
Is that his actual name?
Coincidentally, yeah, but people call him—
because he comes from the number 4 family.
Yeah,
and his parents just named him Trump Employee. It was really one of those fortuitous things.
But his friends call him Yusel Taveras, and that's been reportedly also his name. But he is going to testify against Nauta, and his story is sort of complicated because he was Woodward's client, and the government told Woodward, "We think you have a conflict representing both these guys," and he said, "I don't see one." And then they put him in the grand jury, and he told a story, and then they told Woodward, "We're going to indict him because we have evidence that he lied. We're going to indict him for perjury, and unless he changes his testimony. And we think you now have a pretty clear conflict because, if he changes his testimony, he'll implicate your other client." And Woodward said, "No, I don't see a conflict." And so then he asked for a hearing on conflicts this was now in the DC. This was still in DC. This was during the investigation. So this was the DC grand jury. That judge gave him a new counsel. He switched counsel. He decided, I'll go with the new guy, a new woman actually. And then did change his testimony. Anyway, Woodward, so that is one issue. Woodward used to represent him. And the other issue is there's another witness the government says it may call that is his current client. And Woodward did not see any conflict there either. So a Garcia hearing is where the judge informs the defendant of the potential conflicts and the defendant waives them so that this doesn't become a problem if he's convicted and he says, gee, I didn't have effective counsel, my lawyer had a conflict. And so his first hearing blew up when the government raised an unexpected point. And anyway, basically, I don't know how much you want to go into this. There are two conflicts that present themselves. One is who's going to do the cross-examination, because Woodward has a relationship, probably may know confidential information. He's not supposed to use that against his former client. If he withholds it, he sort of possibly heard it. He's not zealously representing the new guy, Nauta. He's holding back. That's one conflict. And then the one that came up at the hearing, the first hearing, was the government said, well, it goes beyond cross. It's also, what are you going to do at summation? Is he going to impugn the credibility of his former client? And Woodward said, well, wait a minute, this is a new thing. You didn't mention it in the briefs. I think I can do that. We need a ruling, but I can't advise him before. And Judge Cannon was very upset and called off the hearing and said she didn't think there was a conflict. Anyway, after more briefing, it turns out there's a conflict and everyone sort of acknowledged it. And Woodward said, I will get another lawyer to do the cross. I will get another lawyer for the witness. And Nauta waived everything. Yeah, I understand why I waived it. So it's sort of solved.
All right. And so where does that leave us in this case? There's been supposedly discovery going on, but there's a whole lot of SEPA issues, and Judge Cannon doesn't seem to be moving very quickly. Where is the larger case?
She has postponed put off several deadlines because the government, Trump keeps raising objections. And there was a deadline, there were two deadlines this month relating to SEPA Section 4, which is where the government, typically what happens is the government, the government, remember, has turned over the classified documents that are mentioned in the indictment. That happened early, but there's some additional discovery that's classified that they think he probably needs to have, but they are allowed to, they're allowed to ask that be redacted because some of it's ultra secret and not all of it is necessary for either him or his defense lawyers to know. So the procedure is the government files ex parte and says, here's how we'd like to redact this stuff. And what the defense lawyer does is he also ex parte presents sort of a précis of his defenses, his anticipated defenses, and the judge is supposed to decide, well, are these redactions fair in light of the defenses that are being raised? And Trump has prevented that from going forward. He says, regardless of what it says in the statute, I think this should be an adversarial process, not ex parte. I want to know a lot more about what they're withholding. And he actually did this in both cases. And Judge Shutkin said, because there are a few classified documents in the DC case. And she said, no, the statute's clear and there's controlling DC circuit law. Here, there isn't apparently controlling 11th Circuit law. and she's taking all of this very seriously. In fact, it appears that she's never completely resolved the question of whether De Oliveira and Nauta are going to be entitled to see the classified documents that Trump withheld, even though they're not charged with those documents. But she thinks maybe they're entitled to see those too, even though they don't have clearances. De Oliveira has never had a clearance, and there's no apparent need. But she's been withholding. She says she's going to write on that. She's going to write on the fourth SEPA 4. I think there was another conventional discovery motion. She's put those off because Trump says, I can't write those until I see all the discovery first. Motions to dismiss sort of things. So a lot has been put off. There's going to be a hearing November 1st, and that's when really we might find out. Trump has asked to delay the whole trial from May until mid-November, obviously after the election. And so we might find out there or shortly thereafter what she's going to do.
All right. So that brings us to Judge Tanya Chutkan. Quinta, this is the first week in several weeks. We are not going to be discussing Trump's motion to dismiss on the basis of presidential immunity. We will, however, be discussing the government's response to Trump's motion to dismiss on the basis of presidential immunity. There are a spree of Trump motions to dismiss this week. Walk us through what he filed in general, and then tell us about how the government responded to that one particular motion that we've discussed a fair bit.
Thanks, Ben. So yeah, as you say, I'm not going to go in too much depth on Trump's first motion to dismiss, but just as a refresher, this is a motion to dismiss the case against him on the grounds of presidential immunity, essentially arguing that the existing presidential immunity from civil suit under Nixon versus Fitzgerald and Clinton v. Jones should be extended to the criminal context as well. That Trump's actions as described in the indictment fall into that category, and also importantly that the courts should not be able to consider his motives in conducting that analysis. So that's the big one. We also had a flurry of other motions to dismiss on October 23rd, because that was the deadline that Chutkan had set. And it looks like they were deciding to file things right up to the deadline. It's pretty unusual to get multiple motions to dismiss. Usually it tends to just be one that sets out a lot of different arguments, but Trump's team decided to do it another way. We've been speculating in the Lawfare team that maybe this has to do with page limits. We're not really sure. The other motion,
I have seen it done both ways, by the way.
Okay.
It's not unheard of to do it this way.
So the other motion, so the first one is a motion to dismiss on the grounds of selective and vindictive prosecution, essentially arguing that Trump is the victim of a sort of a political hack job, essentially. Carissa Byrne-Hessek, who studies prosecutorial power at the University of North Carolina, has a useful Twitter thread on this, and she described it as, and I quote, "quite awful." Just really overstating the law on the subject. It's quite difficult to get a case dismissed on these grounds, though people do try. And Professor Hessek's argument is that this sort of just doesn't really come close. Trump also has, there are two other motions to dismiss. One is on constitutional grounds, including the First Amendment. And the other is on statutory grounds, essentially arguing that the particular statutes that are at issue here don't actually fit the conduct that is described in the indictment. There's definitely a bit of a spaghetti at the wall approach here, but that's sort of often what you get in a motion to dismiss, so I don't think that's unusual. I will say I was pretty struck by the fact that I believe the constitutional motion to dismiss, there are big portions of it that are basically just copy pasted from the original motion to dismiss on the grounds of presidential immunity. So make of that what you will. So then let me then turn to the special counsel's response to the presidential immunity, circling back around. So Ben and I were very interested to see where this went, because we felt like it would say a lot about sort of how the Justice Department was thinking about the case, or how the special counsel's office was thinking about the case, and where the Justice Department had to kind of come down in terms of its thinking about presidential power. I will say, just speaking for myself, I kind of expected the special counsel to, take maybe a bit of a cautious approach and say something along the lines of, yes, there may exist some sort of immunity on the part of former presidents for criminal prosecution for conduct that took place while they were in the presidency, but this is well over that line. The brief actually comes out swinging and is much more aggressive, and the vast majority of the brief is spent really digging into this argument that there is no criminal immunity for presidents for the conduct of the category that I've described, which I certainly found very striking. And we can talk more about why. From there, like as good litigators do, the special counsel sort of sets up a range of fallback arguments in case the courts don't buy that. One of them is essentially that, there exists immunities that the courts and that the Justice Department Office of Legal Counsel have recognized in terms of presidential conduct that sort of provide a backstop. So, we don't need to be worried about presidents being prosecuted all over the place once they leave office. And they do sort of end on the argument that, yes, okay, even if the court does want to recognize some kind of Fitzgerald-style immunity here, this is just so far over the line that it's simply not within that category. So that is a very, very high level overview of a lot of very complicated arguments. But I hope that sort of sets out the scope of what we're looking at.
So a couple of additional points on this. The government is very clear in this motion that it is only addressing immunity from federal prosecution, thus leaving distinct the question of, for example, if Trump filed the exact same motion in Georgia in Fulton County, this analysis probably doesn't apply, at least not unamended, but and would have to be reformulated in terms of the supremacy clause, I suppose. But it's so it's narrow in that sense. And then there's this weird sense in which the motion it reads really strong, because the whole, as Quinta says, the whole body of it is there is no criminal immunity. But then you get down to the last third of it, and they're like, well, of course, there are criminal statutes that we don't apply to the presidency. And it lists some of them. And then there's the clear statement rule where, we don't apply any statute to the president if there's no clear statement that it applies to the president, and if application would impinge on presidential power. And so they kind of, strip down presidential immunity and deny it exists, only to build it back up and recreate it by other means. But I agree, it's a really striking motion. It is not the motion I expected them to file. And I think it's a motion that, had to have been negotiated carefully with the Office of Legal Counsel. And the fact that the Justice Department is apparently on board with it, I think, is a remarkable change. It's not what Bill Barr's Justice Department would have done, and so I was very surprised by it and actually kind of delighted by it. I think it's a refreshing change for OLC to be thinking about how to pare back some of the more strident presidentialist claims that the office has made, rather than thinking about how to build on them forever. All right, Roger, so tell us about some of the other motions, the constitutional and statutory grounds motions, and also the outrageous prosecutorial persecution motion.
Yeah. So the constitutional one, I should say, you know, in preface, you know, a motion to dismiss is always hard to win in a criminal case. You know, you assume all of the facts in the light most favorable to the government. And so usually it only succeeds if there's something wrong with the statute doesn't apply. So, you know, yes, his first one is about First Amendment protection, but he's really, you know, his premise is all I did is express my First Amendment views about the election, my opinion that I won, my concerns about election integrity, and I petitioned for redress of grievances by, you know, speaking to the vice president about some of these things. You know, obviously that isn't really the way the indictment reads, and you have to, in this circumstance, you have to read the indictment. Just to give, you know, one of the easier examples, the phone call to Brad Raffensperger. You know, he doesn't say, I think I won, Brad. He says, find me, you know, 11,780 votes. And this is very serious, Brad. You know, this could be a criminal matter for you. I would really think about this. You know, it's intimidation, it's interference, it's threats. It's not
well, and it also it cannot be assessed without reference to intent, right? So, you know, if you say it could be a criminal matter for you and you're joking and the person you say it to knows you're joking, that's not a crime. And if you mean it as a threat and it's taken as a threat, it's absolutely a crime. And the words alone don't answer the question.
Which means it can't be decided on a motion to dismiss.
It can't be decided on a motion to dismiss.
Yeah, and then, you know, the other theories are you know, the use of lies to, well, the orchestration of the false electors scheme and so forth and so on. So it's obviously alleged to be more than just anodyne First Amendment expression. One thing that's sort of funny to me about this motion, it's a 31-page motion, and, you know, it begins with a Supreme Court ruling. And, you know, in that situation, you sort of would like to start with a Supreme Court ruling that everyone, that it resonates with everyone, you know, like, you know, Brown versus Board of Education, or, you know, something everyone can get behind. The key ruling for Trump, and it is, you know, it's the appropriate ruling for him to cite. It's United States versus Alvarez. And it's really the Supreme Court's saying that you have a right to lie through your teeth. And, you know, Alvarez was sort of like the George Santos of his time. He was this low-level public official elected in California who at a public hearing talked about how when he, you know, he was a retired Marine, and because of his valor in combat, he won the Congressional Medal of Honor. And it develops that he wasn't actually ever in the military forces. and he did not win a Congressional Medal of Honor. There were some other things that are peripheral. They don't relate to the case. He also claimed to have been a professional hockey player with the Detroit Red Wings. But anyway, he told some, and at the time there was a statute called the Stolen Valor Act that prohibited lies about your military history. And in a very split decision, they did decide that they didn't want, the Supreme Court did decide that they didn't want, the government to become the arbiters of truth, the ministry of truth here. So that's his key case. You can see why.
It's fitting.
Yeah. But anyway, like I say, there's more in there than in the indictment than just saying things that are false. There's actions, there's conduct, there's intimidation, there's threats, and there's exploiting violence. The exploiting the January 6th to further his attempts to further the scheme involving the false electors. Maybe the most interesting constitutional issue he raises, and I think we mentioned this once before, it's a reading of the impeachment clause. And the impeachment clause, and he develops into a form of double jeopardy clause. And he says, here, the clause says, this is from the impeachment clause, the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to the law. So, I mean, most of us would read that and say, well, that shows you that double jeopardy doesn't apply. You could be convicted at impeachment and then you could have to face trial. But he said, but it says conviction. The party convicted shall nevertheless. I wasn't convicted. And so without being convicted, I can't be tried. And so that is, I don't think, I mean, we haven't seen the government's response yet. I don't think that's how most people have interpreted that. I think most people interpret that as saying, we don't want presidents to be indicted while they're in office. And, if you convict him and he's thrown out of office, then you can go after him. And it doesn't really say anything about what if he's acquitted at impeachment and then leaves office.
Actually, we do know how the government responds to that, because they respond to that same argument in the response to the motion to dismiss on presidential immunity grounds, where he makes the same argument.
And he literally makes the same argument, as in the text is copy pasted from one of the motions to the other.
Yes, so we know how the government responds to that, which is to say they give it the deference that it is due. They are very dismissive of it. And, I've been, as has Roger, been lurking around the impeachment clauses since the late 90s. And that is not a argument that is reputable as to the meaning of the impeachment judgment clause. Quinta, you have a point about the statutory motion.
Yeah, just one thing that I think is interesting to note on the motion to dismiss on statutory grounds. So Trump kind of goes through all of the different statutes under which he's charged and has arguments for, why they don't apply in his case. The one that I found particularly interesting is his argument about the charge under 18 U.S.C. 241, which is the conspiracy against rights. So he argues that he was not given what's called fair warning. That essentially he couldn't possibly have known that his conduct amounted to a violation of Section 241 because the statute had never been used to prosecute such conduct before, which is a very nice argument for him to make, since nobody has ever tried to overturn an election as a sitting president before. What's interesting about that is that we've actually already seen this argument made in court in what I believe is at least the most recent example of the Justice Department securing a conviction under Section 241 in an election-related case, which is the case of Douglas Mackey, who is a Twitter troll who posted misleading pro-Trump memes that were encouraging Clinton voters to vote by text. And who was prosecuted under Section 241 and was convicted this spring. Mackey also filed a motion to dismiss, making the same argument that he did not have fair warning, that this kind of online election disinformation constituted a conspiracy against rights under this statute. And the district judge in his case didn't buy it and essentially said, I don't have the quote in front of me, but basically, it is well established that this is a wide-ranging statute that DOJ has used over the last 150 years to prosecute a range of different kinds of election related crimes that have to do with people's right to vote and to have their vote counted. So that's just a district ruling. Mackey has said that he will be appealing. So we don't know how an appellate court might consider that, but I thought that it's just interesting to note that this argument has already been tried, at least before one judge, and hasn't gone particularly well.
All right. We are going to go to audience questions, which are going to go particularly well. Ruth, the floor is yours.
Okay, my question has to do with the defense that someone is following their lawyer's advice after they have lawyer shopped extensively. And in this case, perhaps someone who's hired the best people in the White House to be their lawyers and the best people in the Justice Department to be their lawyers, who all tell them that they have lost the election. And then they go on and find some lawyers who might be reasonably considered not the best people. Can they then go to court and argue effectively that all they were doing is following lawyers' advice?
So, let me ask you, the way you formulated the question, you don't sound all that credulous of this as a defense. Is that fair?
Well, yes, I think it is. I mean, I think that I can understand following legal advice as a reasonable defense, but I also think you can kind of dial your advisor. You can shop extensively and get lawyers who probably tell you anything you want to hear. And then is that as credible a defense after you've had a shopping expedition like that?
Okay, so I have a couple thoughts on this, and I suspect that Roger and Anna and Quinta may have thoughts on it as well. So first of all, the rule for legal advice, a defense based on advice of counsel, is a relatively restrictive one. You have to have sought lawyers' advice in good faith and followed it, and actually believed that you were, complying with the law that way. And so that would be significantly undermined by if you went to multiple lawyers and did the forum shopping that you're describing, and all of the good ones told you don't do that, and one of them even said you're told one of your underlings, get a really good criminal lawyer, you're going to need one, right? I mean, some of this advice was extremely strong, and you followed the other one. Second thing is, you can't plead an advice of counsel defense without waiving the attorney-client privilege. And that makes it very hard if you then put the lawyers on the stand and they turn out to be, a bit nuts and maybe admit that they'd been drinking and, some other stuff, that may really affect a jury. But the answer to your question is, if you can persuade a jury that that you did it in good faith, and you went to Rudy Giuliani and Sidney Powell because you really wanted their earnest legal advice about what you could do, and you followed their legal advice, and the jury believes that, that is potentially a basis for acquittal. If I sound a little bit doubtful that that is going to be what a jury buys when Pat Philbin and Eric Hirschman and are all testifying. And Bill Barr, who's pugnaciously aggressive and will say, "I told him he was crazy," and I'm a little skeptical that that's going to be a successful defense. Rod.
Yeah. For example, the government is going to pursue two tracks here. It will probably argue that the defense is not available for the reasons that Ben and you, Ruth, mentioned. Exactly, that there's a lot of evidence here that he had lawyers who told him this was illegal, the election was over, and he kept hunting for crazier and crazier lawyers, and that he knew Powell. He told people he thought Powell was off the wall, and of course the others will say he should have known or did know that Giuliani had some sort of maybe a substance abuse problem or whatever was going on with him. So I think they will try to block it. Failing that, they will point out all of the things that the caller, Ruth, I think, mentioned, that, and in order to help with that, they have asked that Trump be required to give notice by December 18th of whether he's really invoking this defense. His lawyer went on national television over and over and over and said they were. Trump went on national television once and said he was. But until they do it formally, the government doesn't know. And there's a ton of witnesses who invoked attorney-client privilege, maybe 22, 25. And so they want to know, if you're really saying this, then you're going to waive the privilege with respect to these issues. And we need to know so we can depose more, interview more witnesses. In addition, they've already mentioned that the fact that, well, 3 of your lawyers just pleaded guilty. Jenna Ellis, Sidney Powell, and Ken Chesbrough. And you can't use an advice of counsel defense with a criminal accomplice. And so they will probably argue that that's another complication.
All right. The next question is an Anna special from Tom. With respect to the Meadows appeal at the 11th Circuit, the court has now asked twice, September 12th and October 17th, for responsive briefs on the question, can a former federal official apply for removal? What do you think this means, reading tea leaves? So this is the issue that you earlier described as the 11th Circuit's proof of life. Do you read this as signaling that they're going to say Mark Meadows loses because he's not a federal official?
I mean, I think what it does say is that they're going to answer this question in their opinion, but I just do not know one way or the other whether they will answer in the way that they did in Pate, which is to say that, Mark Meadows loses because he's a former federal official. I think no matter what they decide, though, the answer just cannot be that former federal officials cannot remove under the statute. I think that if they do decide on that basis, Meadows' team would appeal that to the Supreme Court, and I think that the Supreme Court would reverse. And so I have to wonder if, the 11th Circuit is aware of that, because I just think the policy arguments are so strong in favor of including former federal officials for removal. So I think if Meadows loses at the 11th Circuit, it's got to be for he will either lose at the 11th Circuit, for that reason, but then, I think that it just cannot be on that basis that the 11th Circuit decides. And even if it is, it's going to it's something that cannot be ultimately what is decided by the Supreme Court. Sorry for the word salad, everyone.
Yeah, I agree. I mean, there's an argument. I think there's a better argument for removal than a lot of commentators do. And I think there's a good argument against removal, which Fani Willis is making. I think the argument that you're not going to remove because he's not a federal official anymore is quite ridiculous, especially because administrations do come and go. And if you imagine that, like, the policy goal here is to prevent state criminalization of federal policy, so you pass a Texas state law making it a federal crime not to enforce the border, making it a state crime not to install things that'll cut up migrants when they're crossing the Rio Grande, right? And then you just wait till Joe Biden is out of office to indict him. That can't abnegate a federal removal, right? And so I think the idea that whatever the right answer here is, it can't be resolved on the basis of the tenets of the tenure of the service and office at the federal level. That just has to be wrong. But I've gotten everything else wrong in the way the courts are deciding these removal questions, so why should I stop here? Paul, the floor is yours.
Thank you. If Trump's principal defense strategy is to delay until after the election, that leads us to the question, will the pace of the appellate court's dispositions of interlocutory filings be expeditious, deliberate, or fluttery? For a couple of reasons, it might make sense to think about the DC Circuit first, but maybe for extra credit, the questions could be carried down to the path of the 11th Circuit Federal or the state of Georgia appeals.
It's a great question, and I think it's actually one of the key questions if you're asking, if the underlying goal of the question is to assess when these cases are actually going to trial. Look, I will say this. The 11th Circuit has moved quickly on Judge Cannon's prior transgression. It is moving at indeterminate speed on the removal questions. The DC Circuit has been lightning fast on some issues, particularly investigative issues related to the grand jury. It is taking its own sweet time in the Blassingham case, like a year, which is closely related to, though not part of, the criminal case. The Supreme Court has not gotten involved, and so we don't know at what pace it's likely to move. I think it very much depends what panels you get, and I also think it depends on the specific posture of litigation. But I don't know. What do others think?
Yeah, it's a really good question because, I mean, on the one hand, if you can get these, theoretically, you would like to have these tried well before the elections or after, and not right before. And so, I mean, I don't know the degree to which the judges can take into account, gee, if he wins, he'll get rid of these. I just don't know if that's a legitimate concern for a judge to have. You know, I have it, but I don't know. So I think it's a very good question.
Quinta? Anna?
Yeah, nothing to add other than I think the questioner is absolutely right that this is kind of the key issue, and the ability to consistently run out the clock on appellate litigation is something that we've seen Trump use to great advantage time and time again over the course of his presidency. I mean, if you think about the litigation over the House's effort to get former White House counsel Don McGahn's testimony, or to get a hold of Trump's financial records, it took 2 to 3 years to get that information, at which point it was basically completely overtaken by events. So I do worry that we may be headed for something similar here.
Something that I will add is that in Georgia, pretty much all interlocutory appeals are discretionary. So Judge McAfee, if he gets to where it's like really close to the election and, you know, Trump requests an interlocutory appeal, he could just say, we need to go ahead and get this done before the election. And he could just deny any request for interlocutory appeals. And, you know, there's that's, again, subject to his discretion. So just something about Georgia state courts that is a little bit different from, you know, our discussions about federal appeals that might make a difference in terms of the Fulton County case.
All right. I will also just add one other thing, which is that in all of these situations, the Supreme Court's review is discretionary. And so if you imagine that a stay were put on this case or on any of these cases, and the Supreme Court wanted to review it, that could take months. But if you imagine that there's no stay and the Supreme Court says, no, we're not interested, that could take hours. And so the range of possibility here is enormous. And I think we just all have to build it into our understanding of the possible. All right, we have a completely non-substantive question from John Hawkinson. John, the floor is yours for your procedural matter.
Thanks, Ben. I hadn't intended to speak on the administrative point, but I just want to encourage you guys to use the Zoom gallery view for us so we can see all of you at once, where that makes sense. I will toss out a question, though, which is, what do you think of Trump's running up?
I want to address, I didn't have you bring this up to leave it unaddressed. There is a reason I switched to speaker view, and I am potentially... I'm told that the correct name is Brady Bunch view. And there's a reason why I switched away from that, which is if you are not speaking for 45 minutes while 3 other people are, if you're last in the list of people we're going through, it's really tiring to be on display in front of thousands of people without you kind of forget, and you rub your eyes or whatever. And so it's just an effort to make it a little bit easier to do these things live, to let people not be on display and in a fishbowl when they're just sitting there.
Well, I appreciate that. And I did say where appropriate, which is to say, I realize the burden of switching it is a pain. The question I'll toss out.
No, go ahead.
Go ahead. All right. Well, the question I'll toss out is just what you think of Trump's running up $15,000 on his tab in New York. But
yeah, so Quinta, you've followed that more carefully than I have. What do we think of the Trump tax?
Yeah, well, I will say two things. The first is I would like to know how Judge Engeron is calculating these increases. Is he adding $5,000 every time? Are we doubling every time? Because if it's the latter, Trump's situation looks quite different than the former. So I'll be very interested to see what happens on try 3. And the second point is that I'm just really delighted that we finally have a way to actually measure in dollar value how much Donald Trump, how much he values being able to post online. Because it seems so far like he values it $15,000 worth. I don't know if I would put that dollar value on my ability to post, but Donald Trump has the heart of a poster and he cannot be stopped. So we'll see how far he takes it.
There we go. John Bordeaux, the floor is yours.
Thank you. And let me just say, I look forward to following the Instagram account for Roger Parloff's hoodies in the future. I think that's going to be beneficial for all. My question was...
Senator Fetterman loaned this to me.
Well, let me see the shorts, sir. Prove your point. So my question in the Cannon trial is, there seems to be this conflation that, I mean, there's a violation of the Federal Records Act of 1950, Presidential Records Act of 1978, and also Atomic Secrets of 1948. But those are two different things. One is mishandling of presidential records. The other is mishandling of classified information. And it seems like we're focused on the classified information, which seems sexier. But there are two avenues of law, and I'm not a lawyer, that seem at play here. Why are we conflating them into, let's look at the classified information? There's a complete vector of prosecution on just mishandling presidential records. In my view, again, not a lawyer. Thanks.
The answer is twofold. You're right. You could have prosecuted this case to some degree simply as a theft of government property. Those are much less serious offenses than the intentional willful mishandling of classified material. So it's a question of what you would, generally speaking, prosecutors in the absence of a plea deal will tend to prosecute the most serious felony the facts will make out. And so if you've, he's also stolen the paper clips that hold the documents together, but they're not accusing him of that, right? They accuse him of the highest ladder offense. And you often do that to the exclusion of the lower level offenses. And that's what's happening here. Is that a fair summary, Roger?
Yeah, and then you have to wonder, did Biden take any presidential records with him when he left, and did so-and-so and did so-and-so? And, it can get pretty penny ante pretty quickly. So I think I agree with, I think you need to take your focus on the serious stuff.
I think the other Roger's addendum here is important, that no one ever gets prosecuted for stealing pencils from the office, even though we all bring pens home and pads of paper and stuff. There's some de minimis appropriation of your employer's stuff that is just regarded as de minimis, and if it's egregious, you think about it in the civil context, like you sue to recover presidential records or something, but you just don't tend to waste criminal resources on that sort of thing. Okay, Josh asks the penultimate question, or rather the penultimate questioner. Does Trump's public statement that Powell was not his lawyer constitute a waiver of attorney-client privilege? And the answer to that question is no. It may constitute an admission that there was no attorney-client relationship at all, and thus there was never a privilege. But a waiver of the privilege assumes that there was a privilege to waive. And here I think there is a real question whether there was an attorney-client relationship between Sidney Powell and Donald Trump. And it may be that she was never his lawyer, in which case there was no privilege. I don't think it would constitute a waiver of the privilege. Do any of you disagree with that? All right.
Sorry.
Go ahead.
I would just add one thing, which is that I was reviewing some documents that we had obtained through open records requests, and one of them was Sidney Powell's attorney from, I think it was last summer, had been making representations that I believe it was to the Fulton County District Attorney's Office. And then also to the GBI, that Sidney Powell was never the attorney for Trump. So it was just interesting that Sidney Powell is also saying that she was never Donald Trump's attorney. But that's all I have to add.
Yeah, just advice to all of you, free legal advice here from a non-lawyer who's not licensed to give you legal advice. When you want to have a lawyer, have a retainer agreement that specifies that, Anna is my lawyer for this matter. And if you're that way, we all know when we all get prosecuted later, what she was and was not my attorney for. And that's why we always do it that way. All right. The last two questions are both from Nathan Aaron. The floor is yours. But you got to unmute yourself.
Yeah, hey there. I'm working, so I was hoping you could read, but anyways, I'll go ahead and read. First, many thanks to everyone for your thoroughly enjoyable, if not equally bizarre, answers last week to my question: what historical or fictional leader reminds you of Trump more than anyone else? Thank you.
Come on, I get points for the alien, right?
That was great. That was awesome. But in my view, I'll just add, Trump will ring in people's minds at some point far off into the future, not too differently than Nero has over the past 2 millennia, including for the framers. And
wait. I want to make a point about this, which is that the estimable former president Elvis wrote to me immediately after that and said, "You all got it wrong. The answer is Nero." So you are with the great Thomas Hendrik Elvis on this point. I just want to give you the same response I gave Thomas on that, which is Nero at least knew how to play the violin. And, he was apparently a decent musician. What's Trump's skill? What's Trump doing while Rome burns? He's not fiddling. He's not playing the lyre. So I just think it's selling Nero a little short.
Okay, fair point. And then to my question today to everybody, please. Do you see a method for the Republic to come to some terms with Donald Trump such that he can, mostly at least, come clean and save face legally, politically, and psychologically? That's perhaps the only way we can collectively move on finally from him, and short of the termination of his bodily existence.
All right, we're gonna take that in order. Roger, what's your answer to this question?
No, I don't see one short of that last option, and I'm not recommending that anyone act on that last option. I'm just saying no. I don't see anything other than that.
Quinta?
I mean, look, the question of what justice means is a very complicated one. I think that criminal sentence is a very inadequate shorthand. But in this instance, maybe as good as we're going to get.
Anna?
And Nathan, you were just bringing the hard-hitting questions every week. Yeah, I don't know. I mean, it's hard for the Republic to come to some terms with Donald Trump when he doesn't want to come to terms with the Republic, it seems. So I just think that insofar as, I think Quinta's right that this is a situation in which, it's very difficult to say what any kind of justice would mean, or at least what any kind of restorative justice would mean. And so it may end up being that a criminal sentence is the most that we get.
I will just say I very deeply don't believe in justice. I believe in protection of society and of the maximum good that a justice system can deliver in the realm of societal protection. Now, that often means it often maps onto a kind of retributive justice model, but I believe in it for very different reasons than people believe in justice qua justice. And it often leads me to believe that incarceration is not useful, and that people have useful contributions to make. In a case like this, I don't give a rat's ass about justice. I care only about the protection of democratic society and governance. And for that purpose, I think incarceration is a very useful tool. And I believe in the neutralization of threats using the criminal justice system. And if we get something that looks like justice along the way to that, I guess mazel tov to us. And if we don't, I'm perfectly happy with this satisfaction of immediate needs of functional needs of a democratic society, which is to deter other people from thinking they can do the sorts of things that he tried to do, and perhaps more importantly than that, to deter people from thinking they should try to help him or help somebody like that. And so I'm kind of bloodless about this, to be honest. We are going to leave it on that bloodless note. It is, so a few things. First of all, you should all become material supporters of Lawfare, so you can join the conversation. You can be like Ruth and Paul and Nathan and ask your questions. You can have them read, but you can be part of the conversation. Go to lawfaremedia.org/support, become a material supporter, and come into the inner sanctum, the inner circle, the elite, the few, the proud, the Zoom participants. Second thing, we're going to do this again next week. And I know that comes as a surprise. I'm going to be in Texas, but we're going to do this. God only knows what room Anna will be joining us from. And then I think that wraps us for today. You are all great Americans, and we will see you next week.